Welcome back. Oh, if you're hearing us chuckle in the background, it's because, a little bit of what we do here is we're shrinking the world one show at a time. And, you can start finding people to work with. It's not always easy. You can Google them, and then you can find people through that. You can find people through referrals. Or you can find people who know what they're talking about, are willing to come share it, which really is what they do right here. John Hugg is back with us, who specializes in estate planning, business succession planning, and elder law, and is also a frequent speaker on these issues and hosts of many seminars throughout the Seattle area. John, how are you, my friend?
Doing well, Ben. Thanks.
It's good to see you.
It's good to see you.
Did you get out in that sunshine a little bit this weekend?
Absolutely. Yes, can't pass it up. I mean, we haven't had enough sunshine lately, so
we're all getting our vitamin. What is it? Vitamin
D.
Yep,
D.
Nice. Well, let's talk a little bit about when people we talk about shrinking the world. There's a lot of people who are at all different age groups and need different types of plans when it comes to law. And again, as we were talking about at the very top of the hour, you can't really talk to somebody who's 90 the same way you would talk to somebody who's maybe 25 and just having kids, even though they need what's called the same thing, an estate plan maybe, but conversation must be pretty different.
Well, yeah, the conversation is actually completely different, although, I mean, at least one component is the estate plan. And for a younger couple that is just starting out and that maybe has a child, you're going to plan in a particular way. And your focus is going to be mainly on what happens after you pass away, on what do you do with your stuff so that your family is taken care of, so your spouse is taken care of, so that your kids are taken care of, and you're going to plan in a way that those things are going to be accomplished. And yeah, you're right. We approach people, in a particular manner. Well, here, isn't this what's important to you? You tell me what's important to you, and it's taking care of your kids mostly, or taking care of your spouse. And that is very different from how you approach somebody who is already in retirement or, is 70 or 75 years of age, where the issues are totally different. You don't have to worry about the guardian for your kids because they're most likely grown. You don't have to worry about a trust for them either, but you have new and different challenges, mostly turning around, your retirement, long-term care, and your own health care, and how you're going to pay for all those things. And then how does your estate plan fit into that so that you can best accomplish those goals at that point in life?
So it really sounds like, what people's big concerns are and what you're planning for are vastly different.
Absolutely. So again, with the younger couple, it's focusing on what's going on after death. With an older individual, which is sort of the realm of what one would call elder law, it's like estate planning on steroids. It's not just the estate plan. It's not just a will and powers of attorney, but we're focusing on other things that are centered around what happens while you're alive. So various things such as dealing with your own housing issues as you get older and you're not able to, are you able to stay in your house? Can you stay in your house without assistance? And is that the right thing to do? If you're prone to falling, then maybe if you have a split level house, maybe that's not the best location for you to be in. And where do you go from there?
We're dealing with that with my grandmother right now, who is slowly, she's now out of her house. She wants to go back, but it's really not safe.
Right.
And so there's this element of, who's going to control this? And it's really a mishmash. You have doctors getting involved, you have her will, then you have my dad and my aunt. And it really becomes this difficult thing to really deal with.
Absolutely. And, in thinking about this topic, before the show, I was thinking about how ironic it is that at the point in life when people want to be have the least complications and have things be the easiest, that's when things actually get significantly more complicated, because now you have a housing issue, you have a healthcare issue. And a lot of it turns on your health situation and where are you physically and where are you mentally, and then depending on those things, what do we have to do and how do we pay for those things? So if you have to go to an assisted living facility, then how do we pay for those things? Do you have the resources to be able to do it on your own and private pay, or do you need some sort of public assistance, which is generally, for most people, the public assistance realm would be Medicaid, which is different than Medicare. A lot of people don't necessarily distinguish them, but they are vastly, vastly different and cover two different things. And then also VA benefits, but not everybody, of course, is going to qualify for VA benefits. So can you cover things and pay for things privately, or do you need public assistance and you need help to be able to qualify for those public programs?
Well, and I imagine with the elder care that the elder law that you're talking about, there are probably, in a lot of situations, there are the grown kids, when a parent or both parents get older, that are worried about the cost because it starts tapping into inheritance and things like that. So it could probably get really messy.
Yes, it can be problematic. And for somebody who focuses on elder law, and you have to, one of the things that's very tricky is who is your client? And I think the general consensus among elder law attorneys is it is the elder, it is the senior. So even if the children, who are generally the ones that come to you, the children are the ones that come to you and say, we have this issue with mom, we have this issue with mom or dad or whatever, and they want something to be done, you have to look at what's best for the older individual and make sure that they're taken care of and that they don't get shortchanged. And I have had situations where, I've got a 80-plus-year-old client calling me up saying, well, my kids say I should give them the house or put the house into a trust for them. Maybe that's the way to go, but maybe it's not the way to go, because making a transfer of that nature, could disqualify you for a significant period of time from, say, Medicaid benefits. So if you're in your 80s and you need Medicaid within maybe a short period of time, boy, a transfer like that would be devastating, really. So there's a lot of traps for the unwary. And yes, you're absolutely right. You get competing interests and whatnot, and people wanting to make sure that there's something, to inherit.
So there's more to navigate than just where grandma or mom or dad is going to live. I mean, it sounds like by making some of the wrong financial decisions, you may not get the benefits that you thought you were going to get. How many people know that?
Well, you're absolutely right. Yes. If you make the wrong decision, you may not get the benefits that you want or need. I don't know. I don't have any statistics on that. I mean, the goal of
most people don't come to you going, well, I heard, we're going to sell the house, but then we're going to disqualify for our Medicare, so we don't want to do that. That doesn't seem like something that a lot of people talk about.
Right. It isn't you're absolutely right, and that's one of the new challenges about elder law. It's a relatively, by comparison, it's a relatively new area of practice by comparison to something that's been around for hundreds of years. And I think mainly the reason is because people are living longer, so dealing with those issues of older individuals is now more prevalent. And so the conversation is shifting to getting that word out and making sure people understand those things and that they can easily make very significant mistakes, and that it makes it very important to find somebody that is qualified in that area to help them navigate everything.
So when you start talking about making mistakes that could impact how people are able to pay for it, whether that is long-term care or, like you said, medical, how does estate planning fit into that?
Mm-hmm. Well, one part of estate planning is a concept of gifting. People make gifts all the time. But gifting is also can be problematic when you're trying to qualify, let's say specifically for Medicaid. We have what is called, in order to qualify for Medicaid and get assistance paying for long-term care, you have to qualify both medically and you have to qualify financially. And so you can't have assets over a certain level. So the uninitiated may think, well, I'll just give away assets. But we have a period of time called a look back, a 5-year look back, starting with the date that you apply for Medicaid. Then we look back 5 years, and we basically add up all the gifts that are made. So if you gifted away a $400,000 house, you're probably going to be precluded from getting Medicaid for a significant period of time.
What do the gifts have to do with it?
Well, you can't give away assets and then qualify for Medicaid. You used to be able to when, back in the 70s and 80s and whatnot, nobody cared. But then, as we've had...
Then we ran out of money.
Exactly. As the budgets become tighter, it becomes more and more difficult to qualify. And so there's a lot of things that you could do a couple of decades ago that you can't do now. And that's the biggest thing, is making gifts generally to children or to trusts for children. If you don't do it in the proper way, you're going to preclude yourself from receiving benefits for a period of time. That's another very nuanced thing. It doesn't mean you'll never get benefits if you make a gift. It just means you're probably going to be disqualified for a period of time. Then you have to do a mathematical calculation to determine how long that is.
John Hugg joins us with Hugg & Associates, a great friend of the show here, and we're discussing elder law and when people get older, how particularly an estate plan really fits into that. John, so when you start thinking about, not giving money away, this really comes down to making sure you qualify for the benefits that you want, mm-hmm. and making sure you kind of navigate, as you said, the landmines that are kind of set by some of the laws that are out there that people just don't know about. It seems that whether it's financial planning, estate planning, the mortgage business, buying a house, it seems like there are landmines that people can make huge mistakes in almost in every single business or professional entity that we talk about. It's kind of amazing, isn't it, that people can have that many landmines to navigate through?
It does seem quite amazing. I don't know that it necessarily needs to be that complicated, but it's what we have done as a society at the state level, at the federal level, and it's just a layer of complexity that we've created. And of course, lawyers are to blame. So, and I'm being slightly facetious.
And that must make, when you start thinking about elder care, the overview of it, you certainly can't give advice, but the overview of it is, and there's so many different intricacies that it becomes a one-on-one conversation, not mm-hmm. I'm going to go get an elder plan. Right.
And again, it's, as with all other types of estate planning, in my opinion, I suppose you could do a boilerplate type plan, but in this respect, it's probably even more client specific, depending on the client's needs.
But the boilerplate plan isn't going to help you navigate the things that can go wrong.
Absolutely. And that's at least when you're talking about addressing issues for seniors, elder law. I don't think anyone should be trying to navigate that on their own. Things are different as between whether you're married or single, and the level of income that you have and then the level of assets that you have. Some assets are exempt, and there are different types of planning strategies to take non-exempt assets and turn them into exempt assets. For instance, if you've got a married couple, your will should probably change, because if one spouse, a lot of times you will transfer assets between spouses. Transfers between spouses is fine, as opposed to transfers to children. And then one spouse dies, and if the other spouse inherits, they could very well find themselves no longer qualifying for Medicaid. And so you want to change your will to make sure that doesn't happen. Put a very specific type of trust into the will. That's another very common planning technique that is generally used and is very important. And if you fail to do that, well, you may get Medicaid for a period of time, but you're probably going to be disqualified for another period of time.
It's that adage: if you fail to plan, you're kind of planning to fail. It seems like this is another one of those places that that certainly rings true.
Absolutely.
Well, John, thanks so much for joining us. We do have to go to break. Again, John Hugg with Hugg & Associates for estate planning, business transactions, and lots of other legal work they do over there, and they do a great job. When we come back, Tom Faley hasn't been here for a while because he's been running around on vacation, but we are lucky enough to have him join us. Back with us here after the break from Ameriprise Platinum Financial Services. I'm Ben Brashen. You're listening to Brashenomics.